It was a $100 speeding ticket. Nothing serious, just 15 over on an empty highway. But 20 minutes later, Marcus was in handcuffs. His car was torn apart on the side of the road. Seats ripped out, trunk emptied, personal belongings scattered across the pavement like trash. His crime? The officer said 3 words. Just 3 words that gave him unlimited power to search without a warrant, without evidence, without anything except his own claim. 3 words that are completely legal. 3 words that bypass the Constitution. 3 words that you cannot challenge, cannot prove false, and cannot escape. By the end of this video, you'll discover the shocking percentage of police searches that start with this trick, why even drug-sniffing dogs have more legal accountability than a cop's nose, and the one phrase that can protect you. Because here's what they don't tell you. I smell marijuana isn't about marijuana at all. It's about power. And once you understand how this legal loophole works, you'll never look at a traffic stop the same way again. Let's start with what the law actually says. The Fourth Amendment protects you from unreasonable searches. The government can't just rummage through your house, your car, or your pockets without probable cause. Specific, articulable facts that suggest a crime is being committed. For your home, that usually means getting a warrant from a judge. For your car during a traffic stop, the standard is lower, but it still exists. They can't search just because they feel like it. Except, they found a loophole. It's called the plain smell doctrine. If an officer can see contraband in plain view through your window, they can seize it without a warrant. Courts extended that same logic to smell. If an officer claims they smell marijuana, that smell alone becomes probable cause. Your car, which moments ago was your private property, instantly becomes legally defenseless. The moment those words leave an officer's mouth, your Fourth Amendment rights evaporate. And here's the truly insidious part. There is no smellometer. There is no standardized marijuana scent test. There is no certification process for an officer's nose. It is 100% subjective, 100% unverifiable, and 100% legal. Now, you might be thinking, wait, isn't marijuana legal in a lot of places now? As of 2024, recreational marijuana is legal in 24 states. Medical marijuana is legal in 38 states. So logically, the smell shouldn't automatically justify a search, right? Wrong. Even in states where recreational weed is completely legal, police still use I smell marijuana as probable cause. They claim the smell suggests illegal amounts, illegal sales, or impaired driving. In Colorado, where recreational marijuana has been legal since 2014, police still cite marijuana smell in thousands of vehicle searches every year. The game changed, but the trick stayed the same. But here's the statistic that should alarm every driver in America. Take a guess. What percentage of vehicle searches during traffic stops cite I smell marijuana as justification? In states where marijuana remains illegal, legal analysts estimate that up to 70% of vehicle searches begin with those 3 words. 70%. 7 out of 10 vehicle searches don't start with visible contraband or actual evidence. They start with an officer's claim about something you cannot see, cannot measure, and cannot disprove. Even in legal states, the percentage remains disturbingly high, because officers simply reframe the justification. The words change, the power remains absolute. Here's where it gets absurd. Let's talk about drug-sniffing dogs versus human officers. Police canine units undergo extensive training, months of certification programs, regular proficiency testing, documented track records. Every alert a drug dog makes can be challenged in court. Defense attorneys routinely question the dog's training records, false positive rates, and handler bias. The Supreme Court has ruled that police generally need reasonable suspicion before using a drug dog during a traffic stop. If the dog alerts but nothing is found, that false positive goes on record and can be used to challenge future searches. Drug dogs, despite all their training and documentation, face heavy legal scrutiny. Now let's talk about Officer Johnson's nose. Officer Johnson claims he smells marijuana. What's his training? What's his certification? What's his false positive rate? None of that matters. None of that is documented. None of that can be challenged. The courts simply accept that Officer Johnson can detect marijuana by smell based on training and experience. His claim alone is sufficient to tearing your car apart. A highly trained dog with documented reliability requires reasonable suspicion and faces constant legal scrutiny. A human officer's nose requires nothing and faces virtually no accountability. Why? Because it's faster, cheaper, and far less likely to be successfully challenged in court. Officers know this, departments know this, and they exploit it ruthlessly. So what happens when you try to fight this in court? Officer Johnson searched your car based on marijuana smell. He found nothing, zero. Your car was clean. You challenged the search as unconstitutional. Here's what happens in the courtroom. The officer testifies, "Based on my training and experience, I detected the distinct odor of marijuana emanating from the vehicle. This gave me probable cause to conduct a search." Your attorney asks, "Did you find any marijuana?" "No, but the smell was present at the time." "How do you know it was marijuana and not something else?" "My training and experience." And that's it. The judge defers to the officer's training and experience. The search is upheld. Your Fourth Amendment claim is denied. Why? Because appellate courts consistently ruled that trial judges should defer to officers on probable cause questions. It's nearly impossible to prove an officer didn't smell something. You're asking a court to believe an officer committed perjury over a routine traffic stop. This creates a de facto warrantless search authorization. Any officer at any traffic stop for any reason can invoke marijuana smell and conduct a full vehicle search, and you have essentially no recourse. The Fourth Amendment promises protection from unreasonable searches, but in practice, those protections evaporate the moment an officer claims to smell weed. And it disproportionately affects certain communities. Studies show that Black and Hispanic drivers are more likely to be searched during traffic stops, even though contraband is found at similar or lower rates compared to white drivers. The smell justification provides legal cover for searches that might otherwise look like profiling. You can't prevent a search based on claimed marijuana smell. But you can protect yourself legally and create the best possible record for any future challenge. First, never consent. If an officer asks, "Mind if I take a look in your car?" your answer is always, "I do not consent to any searches." Say it clearly, calmly, and respectfully. If you consent, you've waived your Fourth Amendment rights entirely, even if the search was happening anyway. Second, start recording immediately. Pull out your phone and state clearly, "I am recording this interaction. I do not consent to any searches." If the officer claims marijuana smell, but your video shows no impairment signs or suspicious behavior, that video becomes evidence. Third, document everything. After the stop, write down the time, location, and exactly what was said. Memory fades, documentation lasts. Fourth, stay calm and polite. Do not argue. Do not resist. Your battle is in the courtroom later, not on the roadside. The calmer you appear on video, the better your case looks to a judge. You probably can't stop the search in the moment, but you can create the best record for challenging it later. Some states are pushing back. New York, New Jersey, and Virginia have ruled that marijuana smell alone is no longer sufficient probable cause. But most states still allow it, and even in restrictive states, officers adapt. I smelled marijuana and observed signs of impairment. The fundamental problem remains. An officer's claim about an invisible, unverifiable smell can override your constitutional rights. So here's what you need to remember. I smell marijuana is not really about marijuana. It's a legal magic phrase that transforms a routine traffic stop into a warrantless search. It's a loophole that bypasses constitutional protections with 3 simple words. You can't prevent it, you can't disprove it in the moment, but you can protect yourself by never consenting, always recording, and documenting everything. Because the system relies on you not knowing your rights, not understanding the game, and not challenging the process. They're counting on you to comply without question. Now you know better. The system is legal, but that doesn't make it right.